Welcome to everyone to our program today, Defending Against Bankruptcy Avoidance Actions in Complex Financial Litigation. Today, our panel includes two attorneys that are very experienced in bankruptcy, restructuring, and turnaround legal cases. We also have a valuation specialist on our panel. And I will take a moment here to go through a few housekeeping things, and then we will get into the program. The objective today is a lively dialogue with our panel of three speakers. Our program today is jointly produced by Financial Poise that provides education for professional attorneys, accountants, business owners, executives, and investors, and also with the other co-producer, the National Law Review, a legal news website that has analysis on a wide range of legal and business topics. Our objective today is an open, frank discussion. In this context, please keep in mind, nothing here is actual legal or valuation or solvency or other type of professional advice. These are general comments, and if you would like real advice, please retain your own consultant or attorney. And with that, we also have the contact information for each of us in the deck, along with brief bios. If you'd like to ask us any specific questions, please use the contact information and reach out to us directly. Now, it's my pleasure to introduce our faculty today. Our faculty includes Chris Horvey. He is a partner with over 40 years of experience. He is with Raines Law, based in Chicago. Very much experienced in bankruptcy, restructuring, and turnaround law. We also have Bob Buser. Bob is a valuation specialist with the firm of Bodmer Price. Bob is based in Chicago and in Ann Arbor, Michigan. Bob has worked for several decades, both for Big Four firms and also international and regional consulting firms in the valuation space. And Jim Sullivan has worked for several decades as a legal advisor in bankruptcy, restructuring, and turnaround transactions. And my name is John Levitsky. I'm in the forensic accounting and commercial damages practice at HKA Global, based in Chicago, and I do valuation and forensic accounting work. Today's program is part of a multi-section series on commercial litigation involving complex financial disputes. This is the fourth part of the program. Many of you are joining this live, but also many of you are joining this on demand. And if you'd like to hear or see any of the prior broadcasts, they are available on demand. They're listed here. This is the fourth in the series. So we're going to talk about many of the topics that are summarized in the slide deck. And I am just flipping through those to let you know that they are there. Those are materials to enhance your understanding. You're also welcome to use them to take notes electronically or digitally as we go along. So with that, we're going to turn to our panel of three speakers. And we're going to start with the basic fundamental question at the beginning here. Chris Horvey, what is it we're talking about? What is a bankruptcy avoidance legal action?
Thank you, John. Well, let's start at the beginning. A very good place to start. When we talk about bankruptcy avoidance actions, we're typically talking about a situation in which you have an insolvent organization, whether it be an LLC or an S Corp or a C Corp, or an individual for that matter, who for one reason or another has become insolvent. And when you have an insolvency, essentially what you have is an insolvency estate, somewhat like a probate estate. And an insolvency estate consists of the assets and property rights attributable to the insolvent entity or debtor, and they're either owned or held by the debtor or very often by a bankruptcy trustee. And in an avoidance action, the debtor or the trustee is seeking to augment the so-called estate by adding back to it property that was taken, in most cases, without malice, occasionally with malice, by a transferee. The debtor is the transferor, and the recipient of the property or assets is the transferee. And they have taken this property in a manner that causes them to receive more than they should have received if everybody in their same class of creditors was treated on an equal basis. And so the trustee or debtor sues typically the transferee to restore the situation of recovery to an equal situation for that class of transferees, either in a preference or a fraudulent transfer type of litigation. Preferences involve as the name suggests, property in which a creditor was preferred over other creditors, either through aggressive litigation tactics or some other means. And a fraudulent transfer may not actually consist of what it sounds like. There may not be actual fraud on the part of the transferee, but the effect of the transfer would be to give it a greater recovery than it should have gotten had the transfer not been made and had it been treated equally. So that's what we're talking about here. Legal actions typically to avoid or set aside these types of activities and to restore, in essence, the status quo before bankruptcy so that creditors are all treated equally.
Well, thank you, Chris. Jim, we're going to turn to you in a moment, but I also want to add to the introduction. I think I did not mention that you are based in New York and you're with the firm of Seyfarth Shaw here in New York. So thank you, Jim, for joining our panel. So Jim, would like to ask you is, Chris was saying, what is a bankruptcy avoidance legal action? And he answered that. But are they all the same? Are there different types of bankruptcy avoidance legal actions?
Yeah, so as Chris got into a little bit, the primary types of avoidance actions are preference actions. And then the second class of avoidance action is fraudulent transfer action. So a preference action is governed by Section 547 of the Bankruptcy Code. And the intent is to have creditors treated equally by bringing back into the estate assets that were transferred out of the estate just prior to the bankruptcy. Typically, the clawback period for preference action is 90 days, and the debtor is presumed to have been insolvent during that 90-day time period. So a debtor can bring a lawsuit saying that it's unfair to the other creditors that you got paid, but other creditors did not. So the Bankruptcy Code creates a mechanism to avoid those transactions. And the transactions can be, typically it involves like the payment of money during that 90-day time period, but it can also be an improvement of the creditor's position. For example, if it obtained a lien on the debtor's assets during that 90-day time period. The other type of action is a fraudulent transfer action. And it can be either intentional fraud or constructive fraud. Intentional fraud is what it sounds like it is, where typically either the debtor or the debtor in conjunction with the transferee arranges for an asset of to be transferred out of the bankrupt estate with the intention of defeating the rights of creditors. And then another type of fraudulent transfer action doesn't necessarily even require fraud, is the transfer of an asset outside of the estate for less than reasonably equivalent value, which we'll get into that concept a little bit later. So that's a situation where perhaps an asset was sold to a third party, but maybe for a grossly inadequate sum. That would be considered to be a potentially constructive fraudulent transfer. It's not as if there wasn't any consideration paid for it, but in that situation, it requires that at the time of the transfer that the debtor actually be insolvent, because unless a debtor is insolvent, typically speaking, a debtor is able to gift assets if it wants to, right? So it's only really when the debtor is in the zone of insolvency that the law scrutinizes those transactions much more closely, oftentimes giving rise to a potential avoidance action.
So, Jim, where are these legal actions filed? Is this federal court, state court? Is this arbitration? Where do the parties file?
Sure. Certainly in the context of a bankruptcy, they'll typically filed in bankruptcy court. Certainly there are state causes of action. The Bankruptcy Code, Section 544 of the Bankruptcy Code actually provides a federal cause of action based upon an applicable state's fraudulent transfer statute. The elements of a state court or state law fraudulent transfer action are substantially similar to the elements of a federal fraudulent transfer action under Section 548 of the Bankruptcy Code. The main difference is that oftentimes state law provides a longer look-back period. So for a fraudulent transfer under federal law, typically speaking, it will scrutinize transfers of assets or the incurrence of a liability that took place within the 2-year period prior to the bankruptcy filing. But under state law, many states have a longer period of time. For example, in New York, where I am, it's a 6-year look-back period, but other states may have either a shorter look-back or a longer look-back. Each state has its own laws and statute of limitations and what have you in terms of what the look-back period would look like.
Well, thank you, Jim. So, Chris, we talked about what are avoidance actions. We talked about some of the claims. We talked about where these types of claims could be filed. But who can bring these? Could I bring an avoidance action, or I need to have a certain status?
In general terms, what you most often see is the debtor or the debtor's bankruptcy trustee bringing such actions. The trustee is the debtor's legal representative and owner of the action once you have a trustee appointed in a Chapter 11 or a Chapter 7, as opposed to the debtor remaining, quote, in possession and in charge of its legal actions. Now, occasionally, you'll see a creditor committee rather than the debtor or the trustee brings such actions, especially where there are insider transactions and the feeling persists among the creditor body that the debtor is compromised politically or otherwise and should not bring that action. Oftentimes these days, you'll see a different type of trustee other than a Chapter 11 trustee bring such actions. And typically that person is a liquidating trustee under a debtor's or a committee's plan of liquidation or reorganization. In essence, through a consensual agreement adopted in the Chapter 11, the creditors, with the court's blessing, have decided to give those types of legal proceedings to an independent third party or liquidating trustee who's in charge of bringing such actions. So it's a wide variety of people that you'll see as a plaintiff in such actions. Outside the statutory bankruptcy framework and a state court action, you often will see an individual creditor bring such actions because that's what the local state law provides for or requires is a creditor with a claim to bring such an action. Again, it can be a wide variety of people acting as plaintiff in these types of legal proceedings.
Well, Jim, who are some of the types of people that may fall into these categories? Like, are these people or companies that do business with the bankrupt debtor? Or
Yeah,
these executives or stockholders?
it could be any or all of the above. Typically it's anyone who received some type of transfer of an asset sometime during, prior to the bankruptcy filing. Oftentimes, from the debtor's perspective or the trustee's perspective, they're looking for deep pockets, right? So whoever has money is likely to be a potential target of a avoidance action. Oftentimes you're looking at the debtor's primary lender. So if lender obtained an improvement, especially like if the debtor got significant liens on the assets, unsecured creditors are looking to find a way to free up value for the benefit of unsecured creditors. So if they can attack a lien that might be held by the debtor's pre-petition secured creditors, then it opens up value for other creditors to receive a distribution. So oftentimes debtors or trustees or creditor committees are looking for a way to attack the lien position of the pre-petition creditors. But it could be anybody that has received something of value prior to the bankruptcy filing.
Well, thank you. Let's turn to evaluation. We're talking about money to a large extent is one of the key factors in a bankruptcy or a bankruptcy avoidance action. So, Jim and Bob, what type of issues would evaluation expert or could evaluation expert potentially help with regarding an avoidance action?
Sure, John. I can take the first part of that. The way I look at this is a debtor owes money. He could have investors, and I know Jim and Chris have covered the legal aspects of this, but the debtor could owe money to an investor who is a family member or a friend. And, the preferential treatment would be to buy them out before it moves into bankruptcy or within the time window, which allows them to get more money than their share would be in an actual bankruptcy situation. So what's happening there is what's been given up and what's gotten back are not equivalent. And I think Jim or Chris mentioned equivalent value. So from a valuation standpoint, we try to match the two. What was received versus what was given up, are they equivalent? And the way it's described in a preferential transfer or a fraudulent transfer, that's generally not the case. So the valuation person has to step in and apply the concepts of equivalent value, not necessarily fair market value, but from a valuation standpoint, that's where you start with fair market value, and you apply the general methodologies to determine fair market value, and then look at the facts and circumstances of each of the conveyances, what happened on a fraudulent conveyance or what happened on a preferential transfer. So that's where the valuation person would come in, and the key is what was given up is equivalent to what was received. And we'll get more into that as we go through the deck, John.
Yeah, what I would add to that is that I think experts are really critical in a situation where the asset that was transferred is not part of a recognized market, right? So, it's very easy if, we're talking about a stock trade where it's a publicly traded stock and, it's a recognized market and it's easy to value. It's different, however, and most often, it's rarely the case where you get lucky enough where the asset being transferred is very easy to value because of that. More often, it's a little bit tricky, and that's where you need the benefit of an expert to really dig in and analyze the facts and compare it to other types of transfers of a similar assets, during a relevant time period. So I definitely think it's really important to retain an expert that is experienced in valuing the type of asset that had been transferred. The other type of issue that I think experts are critical for is trying to determine whether or not the debtor was insolvent at the time of the transfer. In that situation, the valuation expert would be not valuing the asset that was transferred, but the debtor itself, the company, to determine whether or not the debtor was solvent at the time of the transfer. So you're basically, there's a few different ways to determine that, but one of the ones is you're looking at evaluation of all the assets of the company and comparing it to all the liabilities. And if the assets exceed the liabilities, then the debtor is solvent. If it doesn't, then it's insolvent. And that can be a very tricky analysis. And so oftentimes you're going to need expert testimony to help with that.
If I could interject just one
Please.
comment similar to what Jim has just stated. In fraudulent transfer actions, so-called Section 548 actions in federal bankruptcy court, they almost always turn on two key issues: reasonable equivalency of value and insolvency. And in both instances, it's going to devolve into a battle of the experts for the plaintiff and the defendants on both issues. And, this is why, from a legal standpoint, summary judgment is rarely, if ever, achievable in a Section 548 action, because it's always a fact issue as to reasonable equivalency of value and insolvency, not a legal issue, but a fact issue.
Well, thank you, Chris. Let's talk a little more specifically about some of these avoidance actions. We talked briefly about the different types, and we dive a little more deeply into some of the types. I'd like to get some insights from you. So, Chris, we heard earlier about preferential transfers. And in preferential transfers, are there certain elements that need to be proven by the debtor or the trustee?
Yes, there are, John, and here we're looking at a couple of the uh, slides for purposes of audience perusal. Um, in the preference cases, there are a number of elements which must be proven by the plaintiff, the trustee, or the debtor in order to prevail. The interesting fact or difference in preference actions is that you've got this presumption of insolvency for the first 90 days, such that insolvency is rarely, if ever, an issue in Section 547, unlike Section 548, the fraudulent transfer. But the key elements, aside from insolvency, where there is this heavy presumption, all these other factors are burdens that have to be carried by the debtor or the trustee as plaintiff. And those consist of an action to recover a pre-bankruptcy transfer of property made within the 90 days to or for the benefit of a creditor that enables such creditor to receive more than they would had the transfer not been made, and if it had been a Chapter 7 on the date of or the date preceding the bankruptcy. The creditor has to hold a pre-existing claim. So, creditors hate preference actions because they feel that they've already had to struggle to achieve a recovery in the first instance, and then they get sued later oftentimes by a trustee for having done what a smart creditor often does, which is exert pressure to obtain payment of a legitimate claim. So those are the elements in a 547 or a preference action.
Well, thank you, Chris. Continuing on regarding preferential transfer actions, Jim, are there some common defenses to preferential transfer actions?
Yes, there are, John. In fact, a few of them are listed in Section 547C of the Bankruptcy Code, but there are a few others as well. In no particular order, one of the very common ones is called the ordinary course of business defense. And in that situation, it can be a defense to a preference action if the creditor can show that the transaction was in the ordinary course of business of both the debtor and the creditor, or that the transaction was made according to ordinary business terms. So the first element of that is more of a subjective test. And the second one is more of an objective test, oftentimes typically requiring some type of expert testimony. The second common defense is called the subsequent new value defense. A creditor is entitled to a dollar for dollar offset or defense if it transferred some type of asset or some type of benefit to the debtor after it received the allegedly preferential transfer. So just to give an example, if a creditor received $1,000 60 days before the bankruptcy filing, but then shipped goods with a value of $1,000 30 days prior to the bankruptcy filing, then the creditor is entitled to a dollar for dollar offset, and the entire amount of the $1,000 preference claim would be offset by the fact that the creditor gave new value to the debtor equal to $1,000 subsequent to the date it received the transfer. Similar to that is a defense called a contemporaneous exchange for new value. In that situation, the creditor didn't provide the new value subsequent to the date of the transfer, but at or about the same time as the transfer. So this would be a situation where, maybe similar to like a COD type of transaction or some, basically it happens very closely in time. The debtor pays, maybe some money out to the creditor, and at the same time, maybe receives goods of equivalent value right around the same time. Another defense is something called the safe harbor defense. So the safe harbor defense applies with respect to certain transactions related to securities contracts, commodities contracts, forward contracts, or transfers made by or to entities like a commodity broker, financial institutions, securities clearing agencies, and financial participants. The purpose of this defense is to prevent disruption to the financial markets involving transactions of this type. We could do a whole class probably talking about the safe harbor defense under Section 546E of the Bankruptcy Code. So I'm not going to get into too much detail about it, but suffice it to say that typically speaking, transactions related to some type of financial or securities transaction are often entitled to some type of defense under Section 546E of the Bankruptcy Code. Another typical defense is the secured creditor defense. Secured creditors are allowed and entitled to receive preferential treatment. So if a creditor has a secured claim and they didn't improve their position during the 90-day period prior to the bankruptcy filing, they are entitled to a complete defense. Another defense is the contract assumption defense. So if a creditor has a contract with the debtor, I'll take you back to the sale of goods example. So let's say a creditor has a contract with the debtor and is required to sell goods in the ordinary course in connection with that. If during the bankruptcy case, the debtor assumes that contract because it wants to continue to receive the benefits of that contract going forward, then a precondition of that assumption of the contract is that all defaults are cured. So in that situation, again, the creditor is entitled to be paid in full all amounts related to that contract. So that provides a complete defense to a preference action. And then the final one that I sometimes see, a little bit less common, is the extraterritoriality defense. So that situation pops up when the transaction occurs outside U.S. law. It's a little bit tricky to analyze, but I'll give you a quick example. So I was involved in the Sun Edison case a while back, and some of the debtors were non-U.S. companies with assets and projects located outside the U.S. And some of the defendants that were sued were non-U.S. companies who received payments entirely outside the U.S. There was no U.S. nexus whatsoever. The monies did not originate from a U.S. source. And in that situation, we asserted a defense based upon the extraterritoriality defense on the basis that the Bankruptcy Code was not intended to allow a debtor to claw back monies under U.S. law when the transaction occurred entirely outside the U.S. So those are the ones that I typically see in the bankruptcy cases.
Well, thank you. We talked about preferential transfers. We also earlier mentioned there's something called a fraudulent transfer. Chris, is it exactly the same things that need to be proven to show a fraudulent transfer in comparison to a preferential transfer? Is it the same elements of proof?
It's really an interesting question, John, because on the surface and from a superficial standpoint, they are very much alike insofar as the debtor or its or his or her trustee is seeking to recover from a recipient or transferee who received property of the estate pre-bankruptcy that enabled it to achieve a superior recovery to that of the creditors who are similarly situated or in the same class of creditors. But when you start to dig a little bit deeper, you'll find that they are very different from preference actions. In preference actions, the creditor or claimant or transferee has provided typically equal or fair consideration to the debtor, albeit it's pre-bankruptcy and they've received payment of their claim oftentimes as a result of their own diligence in taking swift action to recover such claim. In a fraudulent transfer type of action, it's kind of the opposite rule where you have either an insider or a non-insider for that matter who has received a transfer or a recovery without providing any or any reasonably equivalent value to the debtor in exchange for what it has received pre-bankruptcy. And the other big difference is solvency. You've got this heavy presumption for the 90 days in a preference action. You've got no presumption in a fraudulent transfer action. In fact, it's kind of the reverse or obverse situation where either the debtor is insolvent at the time of the transfer, or oftentimes in, say, a leveraged buyout, the debtor has been rendered insolvent by and through the transfer. So those are the key similarities and differences between preferences and fraudulent transfers. Fraudulent transfers can either be intentional, such that they are what they sound like they are, oftentimes involving relatives or insiders of the debtor who've gotten an extra benefit or set of recoveries pre-bankruptcy, or, and this is where the heavier and more frequent legal proceedings occur, they can be deemed fraudulent, which involves little or no malintent on the transferee's part, but rather a transfer or giveaway of property for less than reasonably equivalent value, which renders the debtor insolvent or the debtor was insolvent regardless of such transaction. And I think that pretty well sums up the similarities and differences.
Well, thank you, Chris. Jim and Bob, it sounds like reasonably equivalent value is a consideration in a preference transfer action. And in a fraudulent transfer action, adequate value is a consideration. So are they the same thing, and how do you measure them?
Well, I would say reasonably equivalent value, John, refers to a determination of whether the value received is substantially equivalent to the value of the property or service that was transferred. So I had made an earlier comment about what was given out versus what was gotten back, were they equivalent. So it kind of previewed reasonably equivalent value. It's not necessarily fair market value, where fair market value is defined as the willing buyer, willing seller, but fair market value is often the starting point. Now, fair market value uses methods called income approach or measurement of potential future cash flows, same as an income approach, a market approach, comparing the transfer to similar ones that have occurred in the past, and finally an asset approach, measuring a company's tangible and intangible assets, subtracting liabilities to determine value. Now, the courts look at it not exactly as fair market value, and Jim and Chris can elaborate perhaps more on that, but they'll consider the intent of the parties, whether the transaction was arm's length, and any indirect benefits received by the debtor. So there may be a discount from what was received versus what was given up, but the starting point for reasonably equivalent value is fair market value.
Yeah, we'll add
Then-
to what Bob was saying. I agree with what Bob said. From a legal perspective, a type of transaction that used to regularly get attacked was a foreclosure transaction that occurred before the bankruptcy filing. And the U.S. Supreme Court weighed in on those types of transactions in the case of BFP versus the RTC, where they held that a regularly conducted foreclosure sale not involving collusion is not a fraudulent transfer. So by definition, in that situation, it was not so much the value. They weren't really comparing the value so much, but they were more in that situation, the process was what was more important. So they almost kind of treated it as if the foreclosure sale was a sale on a publicly traded market, right? Where the courts like to look at public transactions, and they typically find that is more representative of what value is, as opposed to maybe an expert trying to, after the fact, make an assessment of that. But even if the foreclosure price, the sale price at a foreclosure sale, is substantially less than what any reasonable person might think it is, looking at the transaction after the fact, the U.S. Supreme Court has basically said we're not going to second guess the price if the foreclosure process was pursuant to the rules of laid out by the state's foreclosure process, and as long as it was a good faith sale process, not involving collusion, we're not going to allow for it to be attacked.
Well, thank you. Let's talk a little about insolvency. We've heard that word phrase several times. It sounds like insolvency is often a key requirement in evaluating whether a bankruptcy avoidance action will succeed. So, Chris, how is insolvency determined for the purposes of an avoidance action?
Well, you got to first look at the definition that's laid out in the definitional section 101 of the code. And, there's maybe 50 or so definitions there. And sorry about that. It touches somewhat on insolvency, and defines it as a situation where the value of the sum of the debtor's debts exceeds the sum of the value of the debtor's assets under fair under fair value accounting principles, whatever that means. And John or Bob, you can tell me what it means
Yeah,
far better than I can
right,
describe.
right.
But I know there is such a thing, or I believe there is such a thing as fair value accounting, because I've been through any number of trials where it was the key issue. And in my layman's perspective, what it means more or less is knocking out artificial valuations and replacing them with real ones. For
Right.
example, oftentimes you'll see a whole bunch of asset value inscribed in a uh, under the heading of goodwill, and something like that frequently gets attacked or downgraded when push comes to shove in a trial situation. So I will defer to
Sure.
Bob and to you, John, when it
Yeah.
comes to what does fair value mean in this kind of context.
Yeah, John, I can say that what Chris is referring to is one of the insolvency tests called the balance sheet test, in which the test determines the debtor's asset value, does it or does not exceed its liabilities. And what Chris was saying, we look at those assets on a fair market value or fair value basis, not a book value basis, which represents historic costs, which could understate the value of assets. And the assets to be included would be the capital equipment, the real estate, and intellectual property. So those determinations would be based on fair value, and liabilities would, of course, be also tested at fair value. So that would be the first test under insolvency, called the balance sheet test, which is what Chris was describing.
Well, thank you, Bob.
The-
So you said the first test. So are there some other tests?
Yes, yes. I was going to say that there are three: the balance sheet test, the adequate capital test, and the cash flow test. So balance sheet I just described, and Chris did as well. But the adequate capital test determines whether a company is likely to survive in the normal course of business. That is the debtor expected to have sufficient cash on hand to pay its operating expenses, its capital expenditures, and debt repayment obligations? When assessing how much capital is reasonable, a valuation person can consider the company's historic performance, which is before the bankruptcy action, and industry norms, which is a level that the company could achieve in the future. So those need to be considered in the adequate capital test. And finally, there's the cash flow test. And this method involves the analysis of a series of projections of future financial performance. And generally, you look at scenarios that are a base case, expected growth, lower than expected growth, or potentially above the base case for higher than expected growth. This test is attempting to determine if the company has incurred debts that are manageable and payable as they mature out of the bankruptcy. So it's very similar to the adequate capital test, but it looks at these financial performance cases, these three cases at least, as what could be achieved in the future. Now, evaluation under the cash flow test, the valuation person may also look at various financial metrics, such as debt to equity and quick ratios. A debt to equity greater than 2 is generally a sign of poor performance in the future, with less than 1 being considered good. And quick ratios are the ratio of liquid assets like cash and marketable securities to current liabilities. Here below 1 is a bad sign when you develop that ratio. Now, my experience has been that a company is generally asked to pass all three of these tests to be considered solvent. And this is different than a solvency opinion by an accounting firm, where They may not be able to issue a clean opinion on a company. So it's a different test than what an auditor would do. And I just bring that up because Chris had brought that out under fair value accounting. That's what I've got to add to what Chris was saying there, John.
So Bob, is it theoretically possible that a company could be highly profitable, have a growing customer base, doing extremely well, and not be able to pay its debt and be a candidate for bankruptcy?
Yes, it could be over leveraged, John. They could be, and that's why they're the three tests, and the cash flow test does want to bring into those into the testing process those ratios that relate directly to that type of situation. So it's possible.
And then you'd mentioned looking at some historical financial information. So is valuation a forward-looking concept or a backward-looking concept?
Well, I mean, I would say, it's a forward-looking concept, but looking forward is often based on history. How is this company performing before the bankruptcy filing or the proceedings? Was it at industry norms previous? What happened after that? And can it achieve industry norms in the future? So it is, I think the best way to look at it is to look at it on a forward-looking basis, John.
Well, thank you. Jim, insolvency, when is this insolvency test measured? Is it measured daily, or is it measured on the average over a year, or is it as a one point in time?
Typically speaking, for purposes of an avoidance action, you're looking at it at the time of the transaction. And when did the transaction occur? Sometimes a transaction can occur over a period of time, or maybe there's multiple steps in connection with the transaction. So are you measuring at the first, you measuring at the last, or somewhere in the middle? And sometimes, a fraudulent transfer action or a preference action involves numerous transactions. So typically speaking, it can be difficult, especially when you're asking your expert to conduct this analysis, and you may ask him to do the valuation over a range of dates. Generally speaking, the courts, just for clarity's sakes, if it involves, for example, a transaction involving real estate and there's a deed and it gets recorded, the courts will look at the date of recording. If there's a lien that's obtained and they're trying to attack the lien, they'll look at the date that the lien was perfected, because that's a fairly clear date that you can look to. And it's typically the last thing that happens in connection with the transaction is when these documents get recorded. But in other contexts, it can be a little bit more challenging. And, I think the courts will typically look at it from the perspective of when was the last significant step in the transaction, and they'll look at that date. But, again, it's not always a crystal clear answer.
Well, thank you. Bob, earlier you were talking about fair value, and Chris was talking about fair value, and we were talking about fair market value, and then we heard that fair value for accounting purposes may not be the same as fair value for bankruptcy code purposes. So is there such a thing as a premise of value? And does that make a difference in the valuation?
Well, yeah, what you're referring to are definitions of value, fair market value, fair value, and they're very similar. But a premise of value is in use in a going concern is one premise of value, and the other premise of value is in exchange, in liquidation, either forced or orderly. So there are two premises, in use and in exchange, and they both apply to the definition of values of fair market value and fair value, which again, I say are very similar.
Okay, and then you mentioned something about going concern. So If you're testing for insolvency or doing an insolvency test, assuming it's a going concern, or are you actually looking at what the economics in the solvency test suggest?
The going concern is an auditor's opinion. From a valuation standpoint, we would look at insolvency under the three tests I try to describe: the balance sheet test, the adequate capital test, and the cash flow test. So those would be the valuation tests versus what the auditor does on their side. A little
Okay,
bit different, but I think we're getting to the same answer here.
all right, thank you. Chris, Jim, and Bob, we're down to our closing few minutes. So I'd like to open it up. First Chris and then Jim and Bob. Are there some suggestions you'd like to offer up to our listeners?
Well, the only big suggestion I would have is that if you're an owner or an operator or a manager of a business dealing with a financially challenged or troubled entity, you need to be cognizant of the potential for a lawsuit, and you need to consult with a specialist to see what your options might be and where your best interests might lie. And you need to do so rationally and without fear, because oftentimes you'll see, particularly post bankruptcy, there's a number of law firms who specialize in acting as plaintiff's counsel, and they will bring literally hundreds of preference actions against anybody who got paid within the 90 days. And those actions may have merit, or oftentimes they may not have much merit. So you really can't get buffaloed or ballyhooed by anyone's BS, but you have to determine rationally where your defenses lie and where your best interests lie.
Well, thank you, Chris. Jim, would you like to offer up some suggestions?
Sure. I mean, one thing I often get asked when a company is in financial difficulty, the owner or some officer may say, "Hey, look, we're in a bad situation. I got this other company, or maybe I'm starting this new company. Can I just transfer all my assets to the other company?" And I'll usually, or if not always, say that's probably not a good idea. Will almost certainly get attacked. And when you engage in a type of transaction which would qualify as an intentionally fraudulent transfer, which that would likely qualify for, the number of defenses for an intentionally fraudulent transfer are way, way, way less than the defenses available for a constructively fraudulent transfer. Issues like insolvency don't matter. Issues like valuation don't matter. If you intentionally transfer an asset, you're going to get hit for the value of the entire asset. Doesn't matter what value you may have provided in exchange. It's not going to matter whether the debtor was insolvent. If you're shown to have actually committed an intentionally fraudulent act, you're going to get hit hard. And so be very, very cautious about transactions that occur just prior to a bankruptcy, because they're going to be highly scrutinized and you may be making things worse. So definitely consult with an attorney about what you should be doing and what you should not be doing.
Well, thank you. Bob, or some closing thoughts you'd like to suggest?
Yeah, just from a valuation standpoint, John, we've talked about a number of premises and definitions. Most of the work in bankruptcy is we're going to rely on fair market value as a starting point. We talked about the three main approaches under fair market value. But when it comes down to it, the use of each approach is going to be based on the data available, including performance metrics of the entity, both historical and projected, and any determination of value is going to be based on facts and circumstances, and could also include subjective interpretation of some of that information. And that finally, history may or may not be a guide for future performance, which would affect future valuations. So there are some definitions, but it's how you apply them that are critical.
Well, thank you, Bob. On behalf of Financial Poise, we thank our panel, Bob Muser, Jim Sullivan, and Chris Horvey. And most importantly, we thank you, our listeners and viewers, for joining us either on demand or live while we're broadcasting this during the premiere production of this episode. If you have any questions, our contact information is in the deck, and it's also on the financialpoise.com website. We look forward to seeing you another day on another Financial Poise webinar. This concludes today's program, and take care. Bye-bye.
Thank you.